Hi, this is Dave Bliven, Westchester and Bronx divorce attorney with another episode of Lessons from the Divorce Wars. So this lesson comes in where I represented a client several years ago. She didn't have a lot of money, but I took on her case because the husband made six figures. So one of the very first things that I did in the case was to make an application for interim maintenance, otherwise known as alimony, interim child support, and interim counsel fees. So the problem was she was not a homemaker. She made halfway decent money. And the judge rightly said, well, look, I'm probably going to award your client some counsel fees and some maintenance and some child support, but I'm not going to require the husband to pay 100% of your fees, which is pretty much the rule anyway, unless the disparity of income is really great. Like for a judge to say, I'm going to order the more moneyed spouse to pay 100% of the fees of the less moneyed spouse's attorney, that spouse, the more moneyed spouse, would have to be making many hundreds of thousands of dollars, if not millions, and the less moneyed spouse would have to be either a homemaker or making almost no money at all. And that wasn't the situation in this case that I'm referring to. Wife was out working, maybe making 30, 40,000 a year. And, like I said, the husband was making like 120, 130, somewhere in that neighborhood. Certainly in the context of the greater New York City area, not rich either. And he had to pay his attorney as well. So after the judge said that, I go to my client and I say, look, you're going to have to set up a payment plan with me at the very least to start paying off my bills because I'm not going to get 100% contribution from your husband. To which my client said, yeah, sorry, I have no money to pay you. You're just going to have to wait until the end of the case. And, maybe when we sell our house, then I'll pay you. Well, most attorneys are not going to agree to that deal. Sometimes that might be the case, but most of the time that's really not the case. They want some money from their client as the case is going along, especially if their client has some money to pay. And to make matters worse, then in open court, this client started complaining about me, saying, oh, Mr. Bliven didn't go over the proposed settlement agreement with me, to which I whipped out my notes of our appointment and I showed it to her and I said, well, here's all the notes that I took at our recent appointment where I went over the agreement with you. And then she's like, oh, yeah, well, I guess maybe it just wasn't sufficient. Okay, well, then make another appointment and discuss it with me. I can't read minds as an attorney. I wish I could sometimes. But if somebody says, oh, I haven't had sufficient opportunity to review something with the attorney, then the thing to do is to say, I want some more time to discuss it with you. But then she also started complaining because she was like, oh, well, I don't really have any major assets that I can pull money out of to be able to pay my attorney. And she had executed an affidavit in the case stating that she had about $40,000 in, I forget what it was. It was either an investment account or retirement account or something like that. And then the judge was like, you have an affidavit in the case saying you have money theoretically to pay your attorney. It's just, it's not, like you don't want to withdraw money. It's not I can't. So after things started going sour along those lines, I said, look, if you're making baseless complaints about me on the one hand, but then also saying I'm not going to pay a single penny towards your bills, that's where we had to part ways. So I think the lesson there is, especially if you want your lawyer to be nice to you and extend things like payment plans, where the lawyer is not obligated to do that on a typical retainer contract, be nice to the attorney. It's not a crime to be nice to lawyers, especially your own lawyer, if you want them to extend courtesies to you. Certainly don't start bad-mouthing the attorney in open court and then saying at the same time, oh, gee, can you work out a payment arrangement with me? The answer is probably going to be no in that instance. So you really want to be careful about, how you phrase things. If you think things are going sour, then, schedule an appointment with your attorney. Have a sit down with your attorney and let them know what your concerns are, but not in an accusatory way. There's a way to phrase complaints about your attorney, if you think you have them, that are more questions. And any good attorney is going to feel questions, if that's part of what their job is. So if you have a question like, hey, I'm just wondering, why did you say this to the to the judge, or why didn't you say that? I'm just wondering, et cetera, et cetera. Those are good questions to ask, and like I said, any good attorney should answer those questions. So, that is that for that case. And if you want more answers to similar questions to this, I invite you to check out my blog. You can find it at blivenlaw.net/blog. See you next time. Thanks.